Okay. And with that, I'm going to share my screen and introduce the escrow officer that will be hosting. Let's share. That is not the screen I wanted to share. All right, I think we're on track now. So without further ado, I would like to introduce Jen Videgain. She is going to be walking us through this presentation. Jen is one of our fantastic escrow officers based out of our Madera office. And Jen, do you want to just tell the group just a tiny bit about yourself?
Sure. Good morning, everyone. I'm Jennifer out of the Madera Chicago Title office. I've been with Chicago Title, I believe it's been 12 years, and an escrow officer for, I believe, the last 4 to 5 years. Time flies when you're having fun, so I'm not quite sure there. But I'm very excited to be here today talking with you guys about who's on title and the vesting choices and what they mean.
Great. All right, take it away, Jen.
All right. I'm going to have to say I am a bit nervous. This is my first time presenting, so please bear with me. So we have two starting points when people are coming into or hold title. We have a sole ownership, which would be an individual person holding title. Or you can have co-ownership, where there are multiple people, persons, or entities holding title. And the common types of sole ownership, I don't know why that's not showing up there. We would have um, a single person. I don't know why that's not showing up, Jen. Do you see that? A person, an unmarried person, a widow or widower. This is ownership by an individual who's not legally married or in a domestic partnership. That could be a single man, single woman, single person, an unmarried man, woman, or person, a widow, or a widower. A married person as their sole and separate property would be where one spouse holds title alone. The other spouse has formally or must formally disclaim any interest. So a married person who wishes to hold title in their name alone would require the spouse of the married person acquiring title to specifically disclaim or relinquish their right, title, and interest in the property. This establishes that both spouses want title to the property to be granted to one spouse as that spouse's sole and separate property. That same would apply to registered domestic partners. Next slide, please. Sole ownership vesting would be a single, unmarried, or a widower. I'm so sorry. What happens when someone passes away and title is held under sole ownership? So when title is vested as sole ownership, there's no automatic indication as to who's entitled to the property upon the owner's death, which can result,
Mama, take
which
the blankets out because it has, put them on the, let's,
um, which can result in the property passing through probate. Um, so if a single unmarried person or a widower holds title individually, it is most common when they pass away that their estate would be probated. The same with a married person holding title as their sole and separate property. However, it is worth noting that if the decedent has a will or a trust, but the property was not held in their trust at the time of passing, the probate court will likely consider the decedent's written wishes, again, in their will or trust, as to the disposition of the property. That could very well mean the surviving spouse, children, parents, or siblings of the decedent could stand to inherit. And the same applies to registered domestic partnership. Next slide, please. Community property. Sorry. Community property is where each spouse owns their own 50% community interest in the property. Vesting examples for community property include a married couple as community property, husband and wife as community property, husband and husband as community property, wife and wife as community property, spouse and spouse as community property, domestic partners as community property, and so on. Again, it's owned equally by married persons or registered domestic partners. And then there is community property with right of survivorship. It's similar to community property, but includes survivorship, so the property automatically passes to the surviving spouse. Vesting examples for community property also include a married couple as community property with right of survivorship, husband and wife as community property with right of survivorship, husband and husband as community property with right of survivorship, and so on, including domestic partners as community property with right of survivorship. A joint tenancy is where equal ownership with right of survivorship. Ownership passes automatically to the surviving joint tenant, and it's not controlled by a will. While only married couples and registered domestic partners can hold title as community property with right of survivorship or as community property, anyone can hold title as joint tenants. A tenancy in common is ownership that may be equal or unequal. Each owner can sell or transfer or will their share independently. So multiple individuals, trust, LLCs, etc., with equal or unequal ownership in a property.
So Jen, we do have a question in the chat. Clayton Graham says, I have a question about community property. They didn't type it into the chat. So Clayton, if you'd like to unmute quickly and ask your question, we'll see if we can address it.
Okay, yeah, so I'm going through this circumstance right now, and he owned the property before he got married, and then got married, and he's currently in a trust, but they're going through a divorce. So I'm not quite sure if it's community property, joint tenancy, or tenancy in common. Trying to kind of help him with that, but I'm not exactly sure like what he's looking at exactly.
Did he move the property into the trust?
I believe so. I can't talk to him right now. I'm talking through the son. He's out of the country right now, but I believe so. But he is only on title. So that's what's making it weird.
So it sounds like you may have access to a copy of the current vesting deed. Am I hearing understanding that correctly?
Is that what I need? So yeah, that would help a lot because he needs help. So I would need, what was that again?
The vesting deed. So yes, yeah. So if you want to shoot an email over to myself or Jen or Delilah and any one of us, we'd be happy to see about pulling the current vesting deed, which is going to show how ownership over the property is held currently, and then we can go from there.
Clayton, you can send it to me, hon. I'll take care of it.
Okay. Thank you, Linda.
You're welcome.
And that is a good point to know, is just that current vesting deed is the blueprint of how title is currently held. We do come across people who think they've put their property in a trust, but if we pull the property information and see that it is not in the trust, then we have to go what is currently of record, no matter what their intentions were. All right. Jen, should we move on to the next slide?
Yes, please. So vesting as co-owners, what happens when an owner dies? So when an owner dies and property is held as community property, the surviving spouse keeps their 50% interest. The deceased spouse's 50% interest becomes part of their estate to be probated or distributed by spousal property petition, in which, so the spousal property petition is a process in which the surviving spouse petitions the court to formally declare and confirm their ownership rights to the deceased spouse's 50% interest. Excuse me. I do want to there's a little caveat to that, or a side note. We do have a form, an affidavit of surviving spouse succeeding title to community property. There is a couple of different conditions that must be met for us to do that, but there is a way that we may be able to avoid the spousal property petition when property is held as community property without the right of survivorship, when we have the spouse wanting to retain full ownership of the property. Community property with right of survivorship, the living spouse automatically succeeds to title with 100% ownership once the deceased spouse passes. Joint tenancy is equal ownership rights of survivorship, so the ownership automatically passes to the surviving joint tenant. Tenancy in common, the ownership is interest must be probated or transferred unless the ownership interest was held in a trust. And then I think I'm ready to move on to the next slide. Jen, is there a way to fill everything in at once so I can see it all?
There is. I just wanted people to be able to focus on the type that you were talking about. So, but if you'd prefer that I click through to get everything filled in, I can certainly do that.
That's okay. No, that's okay. I've got it over here. Okay. So other ways of holding title, someone can hold title in their corporation, which is a legal entity that holds title separate from the shareholders. Next would be a partnership. Two or more persons conducting business together may hold title in the name of their partnership. The third is a trust. A title is held by the trustees for the benefit of beneficiaries under the trust. And fourth is a limited liability company, or LLC, which is a legal entity combining elements of corporations and partnerships governed by an operating agreement. And so what happens when an owner dies with a corporation? The corporation maintains ownership, and the death of the shareholder does not affect how title is held. Corporation maintains ownership. The death of the shareholder does not affect title. In a partnership, the real property does not transfer. Title stays in the partnership's name. The deceased partner's partnership interest is probated or transferred. The partnership agreement may contain provisions that outline what is to happen in the event of the death of a partner. And when title—
So Jen, from a title standpoint, what would we need on either of those if it turns out that somebody has passed away? What types of documents would you be asking for from the corporation or the partnership to establish what should be happening?
Sure. So we would likely ask for a copy of the partnership agreement. Then we would check or ask for a copy of the Secretary of State filing. That'll likely give us the names of the partners. Typically, when someone passes away in a partnership or LLC, there are going to be new filings, and it'll give us an idea of what parties we are dealing with.
Great, thank you.
In a trust, The successor trustee handles the interest of the trust. Typically, in that case, when the original trustees or settlers of the trust have passed, and we're moving on to the successor trustee who will be signing all documents for a sale, we are always going to ask for a copy of the original trust and any amendments thereto. And next, with a limited liability company, the LLC maintains ownership. The deceased member's interest is probated or transferred. The LLC's operating agreement may contain provisions that outline what is to happen in the event of the death of a member.
So before we move on, Krista had a question. What if a person buys a house now and they're unmarried? They get married, but they don't make any changes to how they're holding title, and then they pass away unexpectedly. We know that that property would be probated, but is there any certain rule around that? And then if they create a trust after being married, would their current spouse have to quit claim their interest? So it's a lot of questions in one.
That was a lot. So let's tackle the first part. So if they currently hold title, as an unmarried or a single person, and though they've gotten married after, yes, their interest would still need to be probated. Again, that spousal petition may apply. I would suggest that the spouse probably seek legal advice to see if that's something that would apply for them. I guess it would depend on the length of time that they were married and if community funds were used to continue to pay, the mortgage and whatnot. But that would be, I think, a legal question that I'd say they should seek legal advice for. And then I think the next part of that was if they obtained a trust, would the spouse need to quit claim after that? So if that unmarried or single individual wanted to put title to the property in their trust, and it was a separate trust that did not include their spouse, I think for our purposes, for title insurance purposes, we would like to see an interspousal anytime property is being moved from being held one way to another, and there is a legal marriage. We would like to see an interspousal or transfer deed be recorded, but I'm not going to say that that's always legally required. I think for insurance purposes, we would like to see that done.
And then before we move on, just that fine print disclaimer that even though we're going over all of these different ways of holding title, and we have lots of free information on the common ways of holding title, we don't advise anybody on how they should take title. All we can do is share that these are the basic things with regard to each type of holding title. There can be different legal aspects and different tax aspects of holding title in different ways. And that's why we always recommend that if people have a lot of questions about it or seem uncertain, ask them to check with both their accountant and their legal attorney to decide what is best for their unique situation. Would you agree, Jen?
Absolutely, yes. The goal is to educate people so that they can hopefully make the best choice for them, understanding the way that they're going to go on to title, or what how they currently hold title, what that means for them. But certainly we don't want to advise anyone. We just want to educate and definitely refer them to an attorney if they need to understand more about how this is going to impact them in the future.
Okay, so now we'll talk about interspousals, which you've touched on briefly, but have a couple more things to share, I'm sure.
Sure. So the interspousal transfer deed is used to transfer ownership interest in real property between spouses. In California, community property is acquired during a marriage. In California, property acquired during a marriage is presumed to be community property with each spouse owning an undivided 50% interest. An interspousal transfer deed allows the granting spouse to give up their community property interest so that the receiving spouse becomes 100% owner as their sole and separate property. We often see this in cases where maybe someone is coming into title and the lender is not allowing their spouse to go on for whatever reason. The lender is requiring the spouse does not go on title, and so we will present the borrower and their spouse with the interspousal transfer deed. So that's the type of case where we typically see that.
And if somebody recorded a quitclaim deed thinking they were being proactive and giving up their interest in the property, would we still require that interspousal deed for our records?
Yeah, I'm not. When you say proactive, you mean
they get married and they go ahead and have their spouse do that on, when they're changing title or something like that. We just come across that occasionally where, or a parent has gifted them property and they just have their spouse sign a quitclaim deed. Do we go back and try to clean that up, or do we accept the quitclaim deed?
I haven't come across that, Jen, in all honesty, but I haven't come across that. So that's a good question, but I don't know. I'd like to find out. I haven't come across that.
All right, moving on.
How adding someone to title outside of escrow affects your interest and your title policy. So, we're going to touch on uninsured deeds. So a lot of times we do come across related parties who will create deeds and add persons onto title. And so we consider those deeds uninsured. It's when interest to property is sold or deeded outside of an escrow. So there's been no examination of that deed. There's been no title insurance placed on that deed. We typically will require what we call an uninsured deed affidavit that we will have the grantor of that deed execute for us. And we like to, some of the issues that we run into that we like to share with people is that thinking about before you add someone onto title is it the fact that if they have any liens or judgments against them and you add them onto title to your property, those liens and judgments will affect your property. So an example of that is, a parent who wants to add their child onto title as a just in case, in case I pass away, I don't want the property to be probated. So I'm going to add my son and daughter on title with me now. Unfortunately, son may have child support out there and the daughter may have some judgments. And then, mom and dad get ready to sell their property. They open up escrow and we've got all these liens and judgments from the son and daughter, that have to be dealt with then through our escrow. So that is how, uninsured deed affidavits or deeding property outside of an escrow can really negatively impact someone. So that's something to consider. And then how that impacts the value of your title insurance policy. So when you close an escrow and you purchase title insurance, as long as you maintain 100% ownership of the property, you are 100% covered by that title insurance policy. If you deed off some of your interest, you are diminishing your policy by just that much. So, for example, if you deed over half your interest in the property, you are diminishing your coverage by 50%.
Jen, would you say that most frequently happens when somebody gets married and they do want to add their spouse to title, or their spouse wasn't allowed to go on title because the lender didn't want the spouse on title, but they feel obligated to add them after close of escrow. Does that come up the most frequently, or is there another scenario that you deal with a lot?
I would say that that's most common is people adding their spouses after the close of escrow. Um, we get that a lot. And then again, with parents adding their children, people doing things to try to avoid a probate situation. So it's mostly parents adding their children or child to title.
Okay.
Uh, Moving property into a trust. So in hitting on people trying to avoid probate by adding their children, a great way to avoid that is to create a trust and move property from yourself individually into your trust. We suggest contacting a professional, typically an attorney, um, who will prepare your trust and likely deeds to grant ownership of any real property over into your trust. You can discuss with them the tax implications of doing that and the proper way to structure and set up your trust. Maintain copies of your trust, especially any amendments there too. We often see successor trustees, mainly children of the deceased original settlers of that trust, come in and they have no idea how to get a copy of that trust, where to get a copy of that trust to establish that they are in fact the successor trustees. They are the ones with the right to sign on behalf of that trust. Another idea is to talk with the attorney about setting up a bank account for the trust, or maybe even a tax ID number. Those things are required when the original trustees pass away. When we close an escrow, we often see that people who hold title in their trust, they don't have bank accounts specifically set up for their trust. And so when we make proceeds payable, they often don't have a way to receive those proceeds. We issue a check in the name of the trust. And if they don't have a bank account set up for their trust, the bank may not accept those funds because the names of the payees on the check or wire don't match the name on the account. So it's important to consider those things as well when moving property over into your trust. And good idea is to check before you list a property and you're concerned about vesting or the way title is held and how that might impact your listing or how to sign the listing agreement, would be to get a copy of the deed. You can retrieve most from our website using the Chicago Title Premier. You can call customer service. You can reach out to your local sales executive or your escrow officer and ask us for a copy of the vesting deed. You can ask the seller to gather documents. If you know the seller holds title in a trust, or you find out through getting a copy of the deed from us, it's important to ask them to get a copy of their trust together, their partnership agreement, operating agreement, or other legal documents, a copy of any death certificates where applicable. I would say it's important to note if we have deceased trustees and the proper documentation has not been recorded in the county to show that that person is deceased, we will prepare and record an affidavit of death of trustee through our escrow. So it's important to get an original death certificate or give your surviving trustee or even surviving joint tenant if property is held in a joint tenancy. We want to prepare and record an affidavit of death of joint tenant or trustee. We're going to need an original death certificate for recording. So it's important to give your sellers the heads up on that. You can also pre-open if you have a great relationship with your escrow officer or your sales exec. and you're concerned about the way title is held, or maybe some goings on of some uninsured deeds, some transfers, that maybe were not done through a title company, you can pre-open an escrow with us. We can get a jump start on looking at that preliminary title report and let you know exactly what our underwriting department is going to require to be able to close an escrow, and we can kind of get a jump start on that. Again, if you were ever unsure, concerned, call your escrow officer. We can have a conversation, and based on the current vesting, we can let you know what documents might be required, just based off of what we typically deal with. So I suggest linking up, finding your soulmate in an escrow officer, and getting to know them, and having conversations with them. I think it's really important to have a good relationship with your escrow officer. Oh, and then
That concludes our presentation, but at this point, we don't have any more questions in the chat. So if you wanted to unmute and ask a question, you would be welcome to do that.
No questions. Just thank you guys for consistently providing us with information. Thank you guys for your knowledge, your professionalism, and your availability. We really appreciate you.
Thank you so much.
Thanks, Mitch. You're awesome.
Thank you so much.
Well, that will conclude our presentation for today then. If you need any information, a copy of the, oh, go ahead, Kim.
Sorry, I'm good.
Okay. If you need a copy of the Common Ways to Hold Title, if you have any specific questions, lenders, you're also welcome to just check in with us at the beginning of escrow based on how the buyers want to take title, to see what we're going to need to work with you to make sure we're on the same page with all of that. We will be sending out the recording a little bit later, and I see a couple people have asked for a copy of the slides. We're happy to send those. Those will come separately, because we found that when we send an attachment with the recording, sometimes they get blocked by spam, but don't hesitate to reply to the email I send out and ask for a copy of the slides, and we'll get them to you. Hope everyone has a great day, and thanks for choosing us as your title and escrow partner.
Thank you, everybody.
Thank
Thank you so much.